I'd like to talk to you today about a very important topic, and that is what are my rights and obligations after I've been charged with impaired or over 80? So let's take an example. You've been pulled over and the police have decided to arrest you for impaired driving, or you've gone through a ride program and you failed the screening test and now they've arrested you. What do you do at that point? What do the police have to do as well? First and foremost, you need to shut up. You should not say another word to the police other than some very few words that I'm going to tell you about. The police are going to read from a card, or they have memorized that you have a right to retain and instruct counsel without delay, and the right to phone a private lawyer or a 1-800 number for duty counsel in the province. That's your right. When they ask you if you understand that, you're to say one word, yes. When they ask you if you wish to speak to a lawyer, you say yes, right now, please, or simply yes. Now, depending on how long they wait at the scene, they may have an obligation right then and there to provide you with a lawyer, to phone if you have a cell phone, for example. But if they leave the scene fairly quickly, they don't have that obligation. So it really depends on how long they stay at the scene, whether you have that right. And if they don't comply with that, you may have a defense to your case. So they bring you back to the police station. What are they going to do at the police station? They're going to allow you to call either duty counsel or a private practice criminal lawyer. There's going to be a list of lawyers. You can look up on the internet. Usually there's a list at most police stations. You want to speak to a private practice lawyer. They'll try and phone that lawyer. If you don't reach him or her, at some point you're going to be required to speak to duty counsel. It depends on the number of minutes that go by. Take advantage of that opportunity. That lawyer is going to tell you the same thing that I am, to shut up, say nothing, right to remain silent, not a word. I mean, not one word other than the words I just told you. Yes, I want a lawyer. Yes, I understand. So now what happens then? So you speak to the lawyer's going to be on the phone with you for a while. Could be 2, 3, 5, 10 minutes. You're going to ask some questions. They'll answer them, but they're going to tell you two very important things. You have a right to remain silent. You should exercise that right. Say nothing. Don't answer any questions. Don't engage in small talk. All that doing is creating evidence against yourself. The more you talk, potentially the more you slur, for example, or you state incriminating evidence against yourself. Plus, even if you're telling the truth, you can never tell the same story the same way twice. So on this particular occasion, you're going to say something. A year later in court, even though you were telling the truth on both occasions, you didn't get your story straight. What happens? You're going to get convicted. Now, what else is the lawyer going to tell you? They're going to take 2 breath samples in the intoxilizer. They're going to give you a demand for that. You have to comply with that. You have to provide proper samples. Do your best to provide those samples. Between those 2 samples, there's 17 minutes that has to pass. That's our law with intoxilizer law, that they have to wait 17 minutes to try and get a second sample in good agreement with the first sample. Usually between that 17 minutes, the police are going to start asking you further questions, maybe engage in small talk with you, et cetera, ask questions from an alcohol influence report. Would you have the drink? Where were you going? What time is it now? Etc. Answer none of them. Do not say a word. Just sit in your chair, ignore the officer. The bottom line, you just sit in your chair as properly as you can and say nothing, and don't engage in small talk, don't answer questions. Why? You're going to incriminate yourself. You're going to create evidence against yourself. And if the prosecutor tries to introduce a trial, the judge is going to just go ballistic and say, look, that was the proper thing to do, to say nothing, move on, next question. You're not allowed to lead the fact that you said nothing, because everyone wants to talk, but it's precisely the wrong thing to do. Provide the second sample. That's the end of it. If you blow over on both, blow over 80, and they're in good agreement, that is within 20 of each other, rounded down. So for example, 136 rounded down to 130, 117 rounded down to 110. If they're in, that's good agreement. 20 apart, truncated, or rounded down, you're going to be charged. Say nothing after that. Take your release papers and move on. Now you may have a defense because you were smart enough to provide the samples and to shut up. And that's very important legal advice that every lawyer who practices DUI and impaired driving is going to tell you to do, and you should follow it.